Hello again. I spoke the other day about the awful behaviour of some supposed asylum seekers in Britain. It is all but impossible to remove anybody from this country once that person has applied for asylum, no matter how feeble or dishonest the grounds for the application. I thought that examining one case might shed some light on how the process works and the way in which it is habitually abused. A lot of people get the European Court at Strasbourg, which operates on behalf of the Council of Europe, muddled up with the European Union and somehow assume that this court is a thing that we could break free of after we left the European Union. Nothing of the kind, alas. The European Court of Human Rights predates the European Union, and it interprets and administers the European Convention on Human Rights, to which this country is a signatory. There is talk in Britain of withdrawing from the Convention on Human Rights, which causes foolish and misguided people to suggest that this means that human rights would no longer be protected in Britain. This is, of course, complete nonsense. The rights which the Convention on Human Rights guarantees to everybody are all firmly established in British law in any case, and were long before the Convention on Human Rights was devised. We do not need the European Convention to ensure that people are entitled to a fair trial, freedom from arbitrary arrest and torture and so on. Let's see how the European Convention on Human Rights is really applied in practice. In the description to this video, I give a link to the ruling of the court in Strasbourg, which still has jurisdiction in this country, on the case of two Somalis who made fraudulent claims for asylum in Britain. I shall begin by outlining the facts which were not disputed by either party when these men appealed to the court in Strasbourg in an effort to avoid being deported by Britain back to their own country. I am quoting now from the judgment of the court, which was against the United Kingdom. Ready? The first applicant, Mr. Abi Samad Adal Sufi, is a Somali national who was born in 1987 and is currently in detention in an immigration detention centre in West Drayton. On 30th of September 2003, he entered the United Kingdom clandestinely using false travel documents. On the 3rd of October 2003, he claimed asylum on the grounds that, as a member of the Rear Hama, a sub-clan of the minority Ahanzi clan, he had been subjected to persecution by Hawaii militia, who had killed his father and sister and seriously injured him. As a consequence, he had no surviving relatives in Somalia. On the 15th of April 2005, the Secretary of State for the Home Department refused the applicant's asylum application, finding, inter alia, that the fact that he had remained in Somalia until 2003 undermined his claim to be a member of a minority clan. On the 16th of May 2005, he appealed against the refusal of the application on both asylum and human rights grounds, namely Articles 2 and 3 of the Convention. On the 29th of June 2005, both the asylum appeal and the human rights appeal were dismissed by an adjudicator, who found that his account of what had happened to him in Somalia was not credible. On the 7th of October 2005, the applicant pleaded guilty to 2 offences of burglary, 5 offences of dishonestly obtaining goods by deception, and 1 offence of attempting to dishonestly obtain goods by deception. On the 29th of November 2005, he was sentenced to 18 months imprisonment. On the 14th of February 2006, he was convicted, inter alia, of threats to kill and was sentenced to a further 6 months detention at a young offender institution. He was later sentenced to 3 months imprisonment following a conviction for indecent exposure in October 2007 and to 32 months imprisonment following a conviction for 5 counts of burglary and theft and 2 counts of attempted burglary in July 2009. On the 15th of July 2006, he was served with a decision to make a deportation order in which the Secretary of State noted the seriousness of his offences and the need to protect the public from serious crime and its effects. So far, so good. On the 4th of September 2006, his appeal against the Secretary of State's decision was rejected by an immigration judge. On the 1st of November 2006, a deportation order was signed and an application for judicial review of the deportation decision was refused. Okay, so far so good. This young man entered the country illegally, lied his head off, committed endless crimes, was given all sorts of opportunities to appeal against his deportation through the courts. He could hardly have been treated with more fairness. In the end, once he was locked up, ready to be deported, he appealed to the European Court of Human Rights at Strasbourg. What do viewers think? Is that a clear enough case of the sort of person that we would be well rid of? What do you suppose the court in Strasbourg ruled? Let me tell you. The court finds that if the first applicant were to remain in Mogadishu, there would be a real risk that he would be subjected to ill treatment. The court therefore concludes that the removal of the applicant to Mogadishu would violate his rights under Article 3 of the Convention. Not only that, but because we had locked this criminal up, the courts ruled that the respondent's state is to pay the first applicant within 3 months from the date on which the judgment becomes final, €14,500. So not only could Britain not get rid of this supposed asylum seeker, but we had to compensate him to the tune of £12,500 into the bargain. He's still living in this country. It is cases of this kind, which is, by the way, far from being exceptional, which cause many of us to think that the sooner that Britain withdraws from the European Convention on Human Rights and removes the country from the jurisdiction of the court at Strasbourg, the better it will be for us. Check out the official record of this case, to which I give a link. Believe me, it's far from being an exceptional case, and it's not the worst such abuse, not by a long chalk. If ever this country is going to get a grip on the business of people claiming asylum, it will be necessary to cut the European Court of Human Rights out of the loop so that we can simply get on deciding who can and cannot stay in this country.